Constitutional protections for those accused of crimes. Hey, we frequently hear about them, but let's take a look at a real-life case. Case involving a fellow by the name of Gary Otis. Arose in Georgia. There, Gary Otis was 64 years of old. He was accused of murdering a 75-year-old woman in an independent care facility. Also stabbed a 71-year-old man, allegedly. Case went to trial. And on one side we had defense counsel, on the other side we had the prosecutor. The prosecutor made opening statement. Defense counsel made opening statement. And in her opening statement, defense counsel said, hey, he just snapped. It was one of those things that happened and he just snapped, and this all took place. The prosecutor objected, and outside the hearing of the jury, he said, wait a second, under the law, she has to tell us if there's going to be an insanity defense. In this instance, she didn't give us any notice of that, and now she's going forward with an insanity defense. She argued, wait, under the law, I just have to give notice of an insanity defense if I'm going to use experts. I'm not going to use experts here. I'm going to rely on lay witnesses only. Well, the judge heard this, called the jury back the next day and advised them that he was declaring a mistrial, that the conduct of the defense counsel was such that he was declaring a mistrial. Defense counsel said, no, I don't want a mistrial. I don't think there is a mistrial. I simply am going to use lay witnesses here. I didn't need to reveal that to the prosecutor. This case can go forward. The judge said, nope, I'm going to call a mistrial, and he reconvened the new trial in 2 weeks. Well, in the interim, the defense counsel said, hold on. Under the Constitution, someone cannot be tried for a crime twice. That's double jeopardy. In this instance, we already had a trial underway. You improperly called it a mistrial, and now to have another trial would basically be to try this man the same time for the crime, the same crime to which the first trial was underway. Well, the case went all the way up to the Georgia Supreme Court. And at the Georgia Supreme Court, the court heard the arguments on both sides and came away saying, defense counsel, we agree with you. We agree with you. In this instance, you did not need to give notice to the prosecutor that there was going to be an insanity defense because you were only relying on lay witnesses. And in this instance, the judge made a big mistake when he declared a mistrial. But when he declared a mistrial and started another trial all over again, your defendant was going to be basically tried the second time for the same case. That's violation of double jeopardy under the U.S. Constitution, and therefore he is basically out of here. The case is dismissed and he is released. Okay, so what do we learn from this case? What we learn is an important thing. There are U.S. constitutional protections for those accused of crimes. Founding fathers wanted to make very clear that if the state, with all its resources and with all its money, is coming down on top of somebody, accusing them of a crime, that that individual has all kinds of protections, among them the right to face and cross-examine an accuser. The right, in this instance, to be free of being tried twice for the same crime. The right against self-incrimination. They don't have to basically testify against themselves. A lot of these things we've seen, but here we see a real live manifestation of what happens when a judge makes a mistake. And when a judge makes a mistake, when the prosecutor makes a mistake, when the police officers make a mistake, those mistakes are all held against the state and not against the defendant. But that's what the Founding Fathers wanted to see happen, because they wanted to make sure that those accused of crime had all the safeguards necessary to protect them from the state, which sometimes does not always act in the best interests. Hey, we bring you this cases, we're bringing cases every week so you understand how the law works. I'm David Allen.